Question 14. Under which of the following circumstances does the right to private defense of the body extend to causing death of the assailant? A simple and straightforward question. The relevant section is section 100 of the IPC. And the various options are actually different parts of section 100. The options are an assault with intention of committing rape. This is covered by section 100. An act of throwing or administering acid, or an attempt to throw or administer acid which may reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such act. This is also covered by section 100. This is the seventh part which was added to section 100 by the 2013 amendment. And lastly, an assault with the intention of kidnapping or abducting, that is also there. So all three are covered by section 100. The correct answer therefore will be option A, all of the choices. An assault with intention of committing rape is covered in the third part. An assault with intention of kidnapping or abducting is covered by the fifth part. And seventhly, an act of throwing acid, etc. So all three, B, C, D, are covered by section 100. Therefore, the correct option will be option A. Question 15. A inserts his finger into the anus of a woman against her will. Under which one of the following sections of the IPC A is punishable? Again, a very simple question. We are all aware that the definition of rape has been considerably widened by the 2013 amendment. 375 has been overhauled. So many things have been added. So rape is now no longer only an act of penetration or an act of sexual intercourse. So many things are now included in the definition of rape, one of which is inserting an object or a part of the body into the vagina, anus, etc., etc. And therefore, this is clearly falling within the definition of rape as widened by the 2013 amendment. It is punishable under section 376. So the correct option is option B. (375) we have already seen, inserting any object or part of the body. So this will fall under clause B, inserting any object or part of the body into the vagina, urethra or anus of a woman. So clause B will be applicable, and since it's covered by 375, it will be punished under 376 subsection 1. Rigorous imprisonment which shall not be less than 10 years. So the minimum punishment, as you must be aware, for the offense of rape now is 10 years. Please remember this. Minimum punishment for the offense of rape is 10 and the maximum is life imprisonment. 376(1). 376(1) covers normal cases of rape. 376(2) covers aggravated cases of rape. And then comes 376(3), which covers a special case where the age of the girl concerned is under a minimum prescribed there. Question 16. A, B, C, D, and E. 5 persons, A, B, C, D, E, while carrying away property obtained by theft committed in a house. So they committed a theft in a house, and while retreating, while carrying away the property, they fired shots in the air with a view to scare away the inmates from pursuing them. They are guilty of what offense? So what is given to us at the start is that they committed the offense of theft. So yes, theft is committed by them. Now, since while retreating, while taking away the property, while carrying away the property, they fired shots in the air with a view to scare away the inmates from pursuing them. This offense of theft gets aggravated into the offense of robbery. So yes, Smita will move step by step. First, it is theft. Then it becomes robbery. Is it a robbery? First, let me explain whether it is the offense of robbery. What is robbery? Theft is robbery. So theft becomes robbery. Theft gets aggravated into the offense of robbery if, in order to commit theft, or in committing theft, or in carrying away the property obtained by theft. Now we are in the third part. In carrying away the property obtained by theft, the offender voluntarily causes or attempts to cause. In this case, it is causes itself. Death or hurt or wrongful restraint, no. No death is caused, no hurt, no wrongful restraint. But what did the offender do? He voluntarily caused fear of instant death or instant hurt or instant wrongful restraint. Not wrongful restraint, but instant hurt. Yes, by firing shots in the air, they instilled fear of instant death or instant hurt, and therefore under section 390 it is an offense of robbery. Theft is robbery if, in carrying away the property obtained by theft, the offender voluntarily causes fear of instant death or instant hurt. Yes. Now, robbery gets converted into dacoity when the number of persons involved is 5 or more. This is what section 391 says. When 5 or more persons conjointly commit or even attempt to commit a robbery, in this case, robbery has been actually committed, no question of attempt. 5 or more persons conjointly commit the offense of robbery, then every person so committing or attempting, in the other case, is said to commit dacoity. So first it was theft, 378, 379 because it was a residential house, and 382 because they were prepared with the arms. They are armed. They had an arm with them, and 390 because they caused fear of instant death or instant hurt, and then 391 because 5 or more persons were involved. 5 persons were involved. So that is how from 382, 390, it comes to 391. The answer will be they committed an offense of dacoity. Question 17. A signs his own name to a bill of exchange, intending that it may be believed that the bill was drawn by another person of the same name. A commits attempt of forgery, attempt of cheating, forgery. Clearly, it is a case of forgery. And if we look to the definition of making of a false document given in section 464, you will find that in explanation 1, it is very clearly said that a man's signature of his own name may amount to forgery. So yes, Smita is right, it is forgery. He has signed his own name, nobody else's. But signing his own name may also amount to forgery, because in this case he wanted it to be believed that the bill was drawn by another person of the same name. So option D will be the correct option because of explanation 1 to section 464. Question 18. An accused headmaster of a school threatens a lady teacher to sign certain blank papers, and if she does not do so, he would defame her. The headmaster is guilty of what offense? Simple, threatening. It's a case of a threat. He has done nothing else, but he has threatened the lady, and we have to look to section 503 for finding out the offense, criminal intimidation. Whoever threatens another. So whenever threat is involved, we straight away come to section 503. Then we will see what kind of threat is there. If it is a threat for causing an injury to his person, reputation or property, and then we also have to see the intention. if the intention is to cause that person to do any act which he is not legally bound to do, as the means of avoiding execution of such threat, commits criminal intimidation. So for the offense of criminal intimidation, what is required? First of all, a threat. And what kind of threat? A threat to cause injury to the person, reputation or property of another person. And then what should be the intention? The intention is to cause that person to do an act which he is not legally bound to do. In the question, the headmaster is threatening the lady. So there is a threat. And the threat is to cause injury to her reputation because he says he would defame her. So that would amount to injury to the reputation. And what does he want from her? He wants that she should sign certain blank papers. Now, this is an act which she would normally not do and she is not legally bound to do. So now he is threatening her to do an act which she is not legally bound to do by way of threat, and therefore it's a clear case of criminal intimidation. Option B. Question 19. A voluntarily throws into a river a ring belonging to Z with the intention of thereby causing wrongful loss to Z. It's again a straightforward question. Causing wrongful loss to another person. Doing an act with the intention of causing wrongful loss to another person. This is an offense which is defined in section 425. Mischief is the name of the offense. Whoever with intent to cause wrongful loss to any person causes destruction of any property. So there is an act which is done by the offender. What is the act required under 425? Causing destruction of the property. In this case, which is the property? The ring. How is the destruction caused? By throwing it into the river. So yes, the offender has actually caused destruction of the property. And what was his intention? His intention was to cause wrongful loss to the owner of the property, the owner of the ring. And therefore, it's a clear case of mischief. A voluntarily throws into a river a ring belonging to Z. Once the ring is thrown into the river, it is as good as destroying it because it will no longer be available. And the intention is to cause wrongful loss to Z. It's a clear case of mischief. Option B. Question 20. In which of the following cases the Supreme Court of India held that if a Hindu husband converts into Islam and marries again, he will be guilty of bigamy? This case we had done very elaborately in our studies. In the case of 494, Hindu husband converts into Islam, marries again, he is guilty of the offense of bigamy under section 494. The case is Sarla Mudgal versus Union of India, 1995. It was reiterated in 2000 in the case of Lily Thomas. So these are the two important cases where this particular aspect, Hindu husband converting into Islam and marrying again, was considered, and the Supreme Court held in both these cases that the husband will be guilty of bigamy even though the second marriage was contracted under the Muslim personal law. You mind it, if you go literally by the provisions of section 494, that section is not applicable. That section 494 becomes applicable if the second marriage is void for the reason that the first spouse is living. So the first requirement for applicability of section 494, as I will show you, no, it's not given here. All right, the first requirement under 494 is that the second marriage must be void. Now, if the marriage is contracted under the Muslim personal law, the man now having been is being a Muslim, and let's say he marries a Muslim girl, so now factually it is a marriage between two Muslims. If it is being performed under the Muslim personal law, this is a perfectly valid marriage. It's not void. So the first requirement of 494 is not met literally. The second marriage is not void because it is performed, it is contracted under the Muslim personal law. Yet the Supreme Court in Sarla Mudgal versus Union of India held that the second marriage will be void and the husband will be held guilty of the offense of bigamy under 494. So that's how the law stands as of now, and the concerned case, as we've seen, is Sarla Mudgal, and the subsequent case is Lily Thomas versus Union of India of 2000. Then 21. A being executor to the will of a deceased person dishonestly disobeys the law which directs him to divide the assets according to the will and appropriates the assets to his own use. Yes, this is an illustration appended to section 405. It's a clear case of criminal breach of trust because the property was entrusted to the executor and he disobeyed the provisions of law. Section 405 will be applicable. This is the bare provision of 405, and the correct answer will be the option relating to criminal breach of trust. Question 22. Which one of the following is accepted as mens rea for constituting the offense of theft? Simple answer. Option D, dishonestly. How does the section start? 378. Whoever intending to take dishonestly. The word dishonestly is appearing in the intention part, not in the act. As I have been emphasizing, the act under section 378 is moving the property. That's all, moving the property. What is the intention? The intention is to take that movable property dishonestly. Dishonestly means with an intention of causing wrongful gain to somebody or wrongful loss to somebody. So if that is the intention is to take the property dishonestly out of the possession of somebody without that person's consent, that is the intention and the act is moving of the property. Then it is theft, and therefore the correct option is D. 23. What should be the age of a minor to constitute the offense of kidnapping? Again, a simple answer. Below 16 years in case of male and below 18 years in case of a female. If the boy is 16 years or above, it won't be kidnapping. But if the girl is 16 years or above, it will still be kidnapping till she completes the age of 18 years. Question 24. Under which section of IPC rash and negligent driving of a vehicle on a public way is punishable? Now here we are not talking of causing any hurt or grievous hurt or death, etc. of any other person. The mere fact that the vehicle has been driven on a public way in a rash or negligent manner is sufficient to constitute an offense. Rash and negligent driving is an offense by itself without reference to anything, without there being any hurt, any grievous hurt, any death of anybody. So this is one offense which has nothing to do with the consequence. We are not talking here of the consequence of the rash and driving, negligent driving. Nobody might have been hurt. Nothing has happened. It was a clear, simple case of rash and negligent driving. But that by itself is punishable. It's an offense. And the concerned section is 279. Whoever drives a vehicle or rides on a public way in a manner so rash or negligent as to endanger human life or likely to cause hurt. Likely to cause hurt. No hurt has been, need not be actually there. If hurt is actually caused, we will go to a different section. If grievous hurt is actually caused, we'll go to a different section. And if death is caused by rash or negligent driving, we'll go to a different section. 3 different sections for actual consequence. If nothing has happened, even then it is punishable. Then it is punishable under 279. Is there any person who can tell me as to which section will be applicable if there is hurt because of rash or negligent driving, if there is grievous hurt because of rash or negligent driving, and if there is death because of rash or negligent driving. 3 different sections will be applicable. Of course, 304A everybody must be aware of. 304A, rash or negligent driving leading to death. If death is caused by a rash or negligent act, 304A will be applicable. This rash or negligent act may be rash or negligent driving also. So I have been emphasizing that there are certain offences, various offences in fact under IPC, where it is an offence without reference to the consequence. The act itself is an offence without reference to the consequence. Even if it has not caused any hurt to anybody, any loss to anybody, even then it might be an offence. This is one example. Rash or negligent driving by itself is an offence. Clear? (279). Question 25. X along with 4 other armed hoodlums seizes the child of Y and threatens to kill him unless Y parts with his watch and diamond ring. X has committed the offence of. Yes. What should be the answer? X along with 4 other armed hoodlums seizes the child of Y, threatens to kill him unless Y parts with his watch and diamond ring. Yes, Smita, you say B, dacoity. Himanshu also dacoity. Shruti says robbery. Jyotsna, anybody else? What offense is this? All right. So first of all, to start with, it's an extortion. Then extortion becomes robbery, and robbery may become dacoity. Jyotsna also says dacoity. Let's see. First we'll come to section 390, then we'll go to 391 if need be. 390 says an extortion is robbery if the offender is in the presence of the person put in fear. Who is the person put in fear? The father, and the offender is in his presence. So yes, that part is met. The offender commits extortion by putting that person in fear of instant death, instant hurt or instant wrongful restraint to that person or to some other person, and induces the person so put in fear then and there to deliver up the thing extorted. So 390 is applicable. The offender is in the presence of the person who has been put to fear. Who is the offender? X and 4 other armed hoodlums. Who is the person put in fear? Y. And what is the harm? What is the threat? That he would put the child of Y to instant death. 390 is applicable. Once 390 becomes applicable, then we'll see how many persons are involved. In this case, 5 persons are involved, X with 4 other hoodlums. So when 5 or more persons conjointly commit robbery, it becomes dacoity. That's why you are calling it dacoity, I suppose. Okay. Extortion aggravated into robbery, aggravated into dacoity. Dacoity because 5 persons are involved. Robbery because the offender is in the presence of the person who has been put to fear. And extortion because by putting that person in fear of injury, you are taking some property from him. Okay, you all agree? There is a twist here. I want to emphasize that. So everybody agrees that it is robbery, and since 5 persons are involved, so it is dacoity. First it is robbery, then it is dacoity. Is it robbery? I am now, see, 5 persons are involved. So once it is robbery, it will get converted into dacoity. 5 persons are involved, no question about that. But is it robbery, first of all? What is required in robbery? Extortion must be there. Is there extortion in this case? What is extortion? When you cause another person to deliver some property to you by putting him in fear. That is extortion, simple. What are the facts of this case? The hoodlums, or let's say X only, if only X were there, X is putting Y in fear of instant death of his child. That is given in the facts. Is it extortion? Is it robbery? The answer is no. I say it is not extortion. I say it's not robbery. Why? Anybody? If anybody wants to explain, you can switch on your audio. Yes, Mita. Y has been put in fear of injury to a child. Y has been put in fear of injury to a child. X has put him in this fear. Why is it not robbery? Himanshu says weapon is not mentioned. Alright, so suppose I mention the weapon also, that X had a gun with him. Alright, then will it be extortion and robbery? Alright, so let me explain. Anybody wants to say anything? This is a simple fact situation, nothing much is given or required. X along with 4 other armed hoodlums seizes the child of Y, threatens to kill him unless Y parts with his watch and diamond. Yes, there is a threat, but what thereafter? Did Y part with his watch and diamond ring? Did Y deliver the watch and diamond ring to X? Extortion will be there only if the property is actually handed over to the offender or to some other person named by him. Who is the offender? X. X is demanding some property under a threat to cause injury to Y's son. Alright, so one part is complete. As far as X is concerned, he has done whatever he could do. But in extortion, you need a voluntary action from the other side also, from the victim side also. Who is the victim? Y. Did Y actually deliver his watch and diamond ring to X? Nothing is given. There is only, what is given is that X gave a threat to him. We do not know what happened thereafter, whether Y actually handed over his watch and diamond ring to X or not. Maybe Y was brave enough and he did not part with his watch and diamond ring. If Y did not actually deliver his watch and diamond ring to X, it will not amount to extortion. In extortion, there are two actions, one from the side of the offender, the other from the side of the victim. The offender is putting the victim to fear, demanding some property from him, and the victim actually hands over that property to the offender. There has to be handing over, delivery of the property. If that property is actually not delivered, this offense of extortion is not complete. And if the offense of extortion is not complete, then what is not complete? Robbery is also not there. And if robbery is not there, dacoity will also not be there. Because in robbery also what is required? Just see section 390, I am showing it to you. Last part of this section is that he induces the person so put in fear then and there to deliver up the thing extorted. So that property has to be delivered to the offender. If that property is not delivered to the offender, 390 will not be applicable. If 390 is not applicable, 391 will also not be applicable.